When I had started practice in Bombay High Court, there were many terms that were very confusing. For example, if there is a case going on, now the judge will suddenly say that we will not go into the merits of the case. We are just looking at the maintainability of the case. Now there will be another lawyer who would be saying that the judge just looked at the technicalities and not at the maintainability. Then there will be someone who will say that there is one part of this order which is under challenge and another part of order is not. So all this was very confusing. So let us take an example of tax litigation. Say there is an income tax case. Now there is a writ petition filed in Bombay High Court. What would the merits of the case mean? If there is a search action that has happened, so in common parlance it's called writ pad gayi hai. There is a search action under section 132 of Income Tax Act, and there are some gold seized, there are some cash seized, or something of those that are seized. Now when the case is in High Court, say it is in Bombay High Court, and the judge is asking on the merits of the case that what are the things that were confiscated, and then what is the law applicable, and then into the details of the case. That is going to merits of the case. But if the judge is only looking at the, say, maintainability aspect is basically if the writ petition is maintainable in the High Court or not. Basically, can you file this case in the High Court or not? For example, if the cause of action is in Orissa, there is a search action that has happened in Orissa, and the company was basically, say, from Bombay, but the cause of action, the search action has happened in Orissa. Say there was a jeweler who supplied the gold in Orissa, and in the Orissa the gold was seized or whatever. So the judge will see the maintainability of the case, that the cause of action is not in Bombay, it's in Orissa. So the case itself is not maintainable. And third, technicality. If the judge is just asking the question that, for example, that a writ petition will be filed to quash so and so lower court's order. But if the judge is now asking that, okay, we will quash it, but before that, have you asked for this particular remedy that that instead of coming to the High Court directly, have you asked for a particular remedy in the lower court? So this is called a technicality. So in Bombay High Court, there are all these various things that you should know. There is something called merits of the case, there is something called maintainability of the case, and there is something called technicality of the case. So hope it helps.